Good morning, everyone. Welcome to our webinar on AI and the GDPR, ethics and explainability. My name is Sergio Velarde, and I'm a senior associate at Fieldfisher, where I focus on data privacy and technology. I'm based out of the firm's Silicon Valley office in the US.
Hi, everyone. My name is Andrea Ortega. I'm also an associate at Fieldfisher, and I'm also based out of the Silicon Valley office. Today, we'll be covering part 3 of our AI mini-series. If you haven't had a chance to attend our previous webinars on assessing your roles as a data controller or processor and on the principle of lawfulness, please head to the Fieldfisher Silicon Valley YouTube channel.
Today, we'll be addressing some GDPR data protection requirements and the development and the use of AI systems. We'll also cover some of the ethical considerations that surround that. Now, AI has been very much in the public eye recently. I think all of us are watching technology develop, and we're watching it become a more integral part of our everyday lives. I mean, even when I look back at the relevance tech had in my life just 10 years ago, it's amazing to see how quickly things are changing. And of course, all this has been accelerated by the pandemic. And now we've gotten to a state of technological development where tech is not just being used as a convenience tool, but also something that could have actual effects on our lives. Increasingly, organizations are using AI to support or to make decisions about individuals. So yes, while for the past few years you've been able to use your phone to log into your bank account, deposit checks, view balances, and all that hasn't been too controversial, that part of technological development. But now we're getting to the point where those same technologies can be used to have certain effects on your life. So perhaps that same app now collects enough data from your phone and uses AI to make a determination on whether you're worthy of a credit card or a home loan, or even something more outside of that context, perhaps to see whether you're worthy of a job. And I think there's much more of a public awareness now of the sort of effects we want these technologies to have in our lives. And particularly at this juncture where notions of fairness and justice and equality are in the public discourse. So there's a lot to consider from an ethical standpoint. Now, at the outset, it's important to remember that the GDPR will apply only to the extent that you're processing personal data for the development or the use of AI. And the requirements we'll be discussing today are applicable to the extent you act as a controller of the data. Whether you're a controller or a processor is an extremely important legal determination to make, since your role is essentially what determines your compliance responsibilities. And just a reminder that a controller is an entity who determines the purposes and the means of the processing of the personal data. And as Andrea mentioned, you can check out part 1 of our AI webinar mini-series to get more guidance on that specific topic on what to take into account when you're making that controller processor determination.
Yes, that's right. I think that also at the outset, it's important that to note that there are different types of AI. So for instance, there's, machine learning, deep learning, or neural networks, and also very different types of use cases. So this would include digital assistants, smart home devices, certain recommendation algorithms, and also facial recognition systems, among others. And in particular, facial recognition has raised many alarms from an ethical standpoint this past year. Note, however, that not all AI use cases are privacy intrusive or will present an ethical dilemma. In our discussion today, we're focusing on those AI systems that do process personal data, and especially those that present a risk to data protection and that have legal effects on individual rights. So mainly those use cases where fairness, transparency, and explainability present more challenges. In addition, and although we're focusing today on the GDPR, for organizations that do have a global presence, there may also be other applicable laws and regulations that should be considered. This would include, and as you're seeing in the slides, from an ethics standpoint, the European Convention on Human Rights, also local anti-discrimination laws, and also local data protection and consumer right laws. In addition, and since we're really at a very early stage of AI development, the legal and regulatory landscape are constantly changing. So for example, just last week in the US, the FTC released new guidance on how businesses can promote truth, fairness, and equity in their use of AI. And also last week, the European Commission published its comprehensive proposals for the regulation of AI. These are only several very recent developments, and they show there is really a lot going on in terms of new requirements, recommendations, and proposals to address the risks and also the benefits of AI developments. So in any case, and if we focus on the processing of personal data of individuals who are in the European Union, so far the most important requirements for businesses implementing AI will come primarily from the GDPR.
That's right. And the GDPR is a principle-based regulation, which basically means that any processing of data in the development or the use of AI has to be done in accordance with a number of fundamental principles that the regulation itself lists in Article 5. And we have this on the screen, and each of these principles can lead us down a rabbit hole. But for purposes of today's webinar, we'll address the important principles of fairness and transparency. Now, these principles are deeply intertwined. They overlap to a large extent, and they raise not only data protection, but other ethical considerations as well. So what is fair? What is fairness? That's an old question. If you were to ask, 10 of your friends what fairness is, you likely get some commonalities, but you also get some key differences. And these will probably come from your friends' background, their cultural upbringing, their personal experiences, their philosophical views, the society they live in, all these things. And thankfully, our task is not so broad, and we do have some guidance on how to assess the question of what is fair. So to start off with the definition, in October last year, the European Data Protection Board, the EDPB, released some guidance on the requirements of data protection by design and by default. And they provided us with a definition of fairness that states that fairness is an overreaching principle that requires that personal data shouldn't be processed in a way that is detrimental, that's discriminatory, unexpected, or misleading to the data subject. And that's a lot to take in, but in practice, Andrea, what have you seen come up in your own practice in terms of actual implementation of this fairness principle?
Yes, so as you were hinting at, I think it's important to highlight that the notion of fairness itself is context dependent and should be defined according to specific use cases and impacted regions with the relevant stakeholders, which would obviously include the impacted individuals. And one way to define unfair behavior is by its harm or impact on people. And there are indeed many types of harms that AI systems can give rise to. So some developments and studies have shown that algorithms and models are no more objective than the people who create them and the personal data that is being used for the training. And it's here important to note, I think, that since AI at its core is trying to mimic the human brain and human intelligence, I think it's interesting also to draw the comparison with the human brain to understand some of the issues. So if we think of a child during its development, and here I have to say I'm gonna inspire this example on Dr. Bruce Lipton. So if we think of a child during its development, as I was saying, our subconscious mind is the first part of the brain that develops when we're young, and it learns programs that come from absorbing our family, our community, society, and all this information is downloaded. There is no conscious mind at an early stage of development to filter the programs, but luckily we humans are not necessarily stuck with the programs we downloaded, because fortunately we also have the conscious mind. And when we start operating with our conscious mind, we can start filtering and we can change the programs we have learned. But this is not the same with algorithms. Algorithms, in contrast, they absorb all the data that's injected to them and any filters that are created by humans. But the algorithms themselves obviously don't have nor are capable of developing any consciousness. So they can't filter the programs or the data. So these are AI systems. They only consider all those programs and data inputted. And this is why they reflect and amplify human programs and human biases, and may result in decisions or recommendations that may be systemically unfair to certain categories of people, or that may not tell the whole story. So for example, if a facial recognition system identifies African American and Asian faces incorrectly 10 to 100 times more than white faces, would it be fair, would you say it would be fair to use it, for instance, in the criminal justice system? Or there's other critical examples that would include credit or application rejections. So such use of personal data in an AI system would be indeed in contravention of the fairness principle. And if we move on to the requirements, this GDPR principle requires all processing of personal information to be conducted with respect for the individual's interests and expectations, considering possible adverse consequences processing may have on them, and also having regard to the relationship and potential power imbalances between them and the controller. So for instance, we would consider the power imbalances between an employer and an employee. So this includes, but is not limited also to implementing measures to prevent the arbitrary discriminatory treatment of individuals.
Yeah, I think that's right. I mean, I think in the context of the AI use, yeah, well, context is really important, like the views of a particular society or a community on what is fair and discriminatory. And the Dutch DPA, for instance, has highlighted the question of whether or not the output of AI is fair is inextricably linked to both the circumstances at hand and the subjective views on justice. So this ability to explain the decision becomes even more important. And the Dutch DPA also states that, you know, a controller must actively account for and justify why an algorithm is fair, and the use of the chosen algorithm doesn't lead to inappropriate results. Now, practically speaking, I think it's worth emphasizing that the quality of the training data, as well as the features used, can in many instances be substantially more important than the quantity of the data. When you're training a model, it's important that the selection of the training data is representative of the tasks to be solved later. Huge volumes of data are of little help if they only cover a fraction of what the model will subsequently be working on.
Yes, that's right. And if we start moving to practical takeaways, I think also that a lot of training and awareness is required to develop AI from a privacy by design and by default perspective. So human biases are mostly unconscious, and therefore teams need to become aware of their biases and how they could possibly inject them into the AI systems when they're developing them. Managers on their part need to understand the concerns around fairness and how to build diverse teams and define incentives for AI bias and detection and mitigation. And for each specific use case, teams would have to consider how the notion of fairness would be defined, analyze the data to be used and how it's going to be used, the impact on individuals, among other important data protection concerns, also assess the statistical accuracy of the algorithms and thoroughly test them before deployment. And finally, and importantly, continuously monitor the system to detect and mitigate any concerns and imbalances that might come along the way. And this whole process and any trade-offs should be documented on an ongoing basis.
Yeah, and I mean, I think in a nutshell, if you're looking for a practical way of helping your organization with these requirements, I think if you got a simple checklist, it would be, you know, one, start with the RAP foundation. This means that you involve as many diverse views and groups as possible in the development of the AI, and try to do so earlier in the stage of development, let's say at the stage where the type of data to be used is being considered. And that's to ensure that any bias is identified early on. I mean, there's a data protection component of that, but there's also the functionality of it too. If the product's not going to work in the end anyway, it's of no use to limit yourself like this. Another, I think, practical step is that testing your models constantly and developing a framework where the AI is regularly checked for discriminatory or unfair outcomes is really important.
Yes, I would also add that it's important to pay particular attention to special categories of data, so sensitive data, as this may require a more nuanced approach in the assessment. And then finally, I guess privacy by design and by default requirements should be deeply intertwined in your approach to the development and use of the AI. So once the right foundation is in place, it's also crucial to be very open about how the organization uses the personal data. Companies often get in more trouble not for their use of the data, but for what they say the uses are that end up being not consistent with their actual practices.
Yeah, and that takes us to the transparency principle. And the way it intertwines with the fairness principle is that if an AI system isn't sufficiently transparent, it may be impossible for those overseeing its use to identify bias in its reasoning and in its output. And as we discussed earlier, that would be unfair. Now, data protection is very much concerned with protecting the rights of individuals to decide how their information is used. And this requires that controllers are transparent about the use of the personal data. And it's important to point out that transparency goes beyond the GDPR. It's definitely important in the GDPR context, but it's becoming more important even outside of this data protection context for the branding of companies that they want to portray and so forth. And for GDPR purposes, transparency is generally achieved by providing data subjects that with processing details. What that means is, you disclose how the information will be used that you're collecting, how the data is collected, who will be shared with, the rights that individuals can have regarding that data, and the information has to be easily available, has to be offered in a clear and comprehensive language. That means you can't hide behind, contractual, complicated legalese. You have to be very clear, and you have to allow the data subject. You have to provide them with enough information to allow them to exercise their rights. And obviously, this can be challenging, particularly in the AI context. What issues have you seen come up with transparency on there?
Yes, well, so firstly, I think there are challenges around how much information you need to provide to individuals, given commercial or intellectual property related concerns. Because basically you want to be transparent to the individual, but not provide so much information that you're giving away your trade secrets, for instance.
Right, right. And I mean, these other rights like IP rights and the like, they have to be balanced against a data subject's right to be provided with meaningful information. Now, practically, that means that yes, when you're forced to make a decision, you need to carry on, you'll make a call. But what will protect your organization is the fact that you took the time and made a good faith effort at balancing these considerations. That weighed in the data subject's right along with your own organization's rights. It could be in the litigation context, in the IP context, and importantly, that you also made a record of your balancing of these considerations. That record that you make will also help you fulfill your accountability obligations, which is another principle that the GDPR requires of controllers.
Yes, and in addition, it's important to note that AI is complex and difficult to understand and explain. So it's difficult to explain how information is correlated and weighted in a specific process. Models often produce results without any explanation, and this has been generally referred as the black box problem. So basically, you're putting data in, you're getting results out in the form of predictions based on that data, but you don't really know in most of the cases what happens inside. And again, it's interesting to extrapolate this to the human brain. A lot of times we as humans, we're thinking, we're focusing on the inside, and the subconscious kicks in autopilot. And the moment thinking occurs, whatever you're doing, you may be driving or walking, subconscious takes over. You may remember those times when you're so focused on a line of thought that you suddenly ask yourself, how did I get home, no? Or how did I get to work? If you were driving, you didn't lose control of the car, but your subconscious kicked in and performed the driving program. Um, but you can't really explain what happened. And similarly, and since our brain and undoubtedly very complex and in a different way also, but AI is very complex and it often doesn't come with an explanation, and it's difficult to explain and find a way to convey to individuals how it reached a certain decision. So, Sergio, what specifically do we have to consider when complying with the principle of transparency?
I think a good way of thinking about the GDPR transparency requirements is that you're basically required to provide certain information to individuals whenever you're collecting or you're processing the personal data. So Articles 12, 13, and 14 cover these considerations. But we also have Article 22, which creates another layer of additional disclosures for whenever data is being collected for purposes of automated decision making. And the way Article 22 intersects with AI is that using AI is a form of automated processing. And there may be times when the model itself is making decisions. An example of this would be, let's say, an automatic speed camera that records your image and based on that imposes a fine. If you're using AI in this way, that'll be caught by this automated decision-making requirements of the GDPR.
Yes, and importantly, the GDPR bans automated decision making if it produces legal effects concerning the individual or similarly significantly affects the individual. However, there are certain exceptions to this provision. For instance, if the automated decision making is a necessary condition for entering into a contract, if a local member state law permits it, or if it's based on the explicit consent of the individual. Additionally, also automated decisions that involve special categories of personal data, so sensitive personal data, are permitted only if the data subject has consented or if they're legally warranted. Note, however, that in order to meet the requirements of the GDPR, the decision must be based solely on automated processing, and it must produce legal effects or similarly significantly affect the individual. But this is quite not very clear, Sergio. So what does it mean for automated decisions to be solely based on automated processing?
I mean, that an automated decision must be based solely on automated processing means basically that there cannot be any form of human intervention in that decision-making process. And human intervention then means that a natural person, like a real life human being, has undertaken an independent assessment of the underlying personal data and is authorized to, let's say, re-examine the recommendations that the models produced. Another consideration is that the GDPR doesn't define what is meant by producing legal effects concerning the individual. But this has been interpreted to mean that automated decision must impact the data subject's rights or duties. And this could be your legal rights, your rights set out in a contract and so forth. For example, we discussed earlier, if you're rejected from a credit card application, from a job, or you're denied entry to a country, presumably all those would count. There are legal effects on you.
Yeah, also the alternative, which is that the automated decision similarly or significantly affects the individual, has been interpreted to have the potential to affect the circumstances, the behavior, or the choices of the person who is subject to the automated decision. Yet it's really difficult to state precisely where the line should be drawn because there are considerable subjective elements here that
Right.
come
And I
into
mean,
play.
right. And in the context of automated decision making, I mean, what would you say the transparency principle requires?
Well, the transparency principle here requires informing data subjects before the automated processing commences or begins that their personal data is being collected for use in an automated decision-making process. Also, the underlying logic of the model. So, for instance, how the data is to be weighed and correlated, and the significance and anticipated impacts of the automated process. Also, the individual must be able to demand that a human takes the final decision instead of the AI system and must be informed about this right not to be subject to automated decision making. Further, after the automated processing has taken place, the individual has a right to request an explanation of the content of the decision. In other words, an explanation of how the model arrived to a given result. And the right to an explanation that does not necessarily mean that the black box must be opened, but the explanation has to enable the data subject to understand why a particular decision was reached or what needs to change in order for a different decision to be reached. The data subject must be informed as to how she or he can oppose the decision, either by appealing or by requesting human intervention. And here, The ICO and the Alan Turing Institute, for instance, have issued guidance on explainability and proposed at least 6 types of explanations that you might give to individuals in different circumstances, and we have included them here to guide the audience. You can see the detail in the slide, but basically you want to make sure that you're explaining how the AI is fair and the impact of the AI. So for instance, if that somebody may not have their application reviewed by a human, and what are the rights the individual has to human intervention.
Right. And so what do you think happens if, let's say we're using AI as a tool, not relying on it in its entirely, but just as a tool to help reach a decision, and we have human intervention? Do we still have these transparency obligations?
Yes, so let's say that an individual uses the information produced by the automated process to reach a decision, for example, by employing a decision support tool. Here, and even though it would not fall under Article 22 regarding automated decision making because there's human intervention, the GDPR transparency principle still applies and requires that the data controller be transparent about the processing it is conducting.
Yeah, I think there's a lot to digest here already. I'm conscious of the time. I think in terms of practical application of these principles and rules with transparency, it's important to keep in mind that practically this means, one, you should be aware of instances where you are using or will use personal data for automated decision making. So you can provide the necessary disclosures to data subjects. And this requires a certain degree of communication within the organization, so that your product teams are talking to compliance and legal, so that you're aware that this is happening. There also needs to be close collaboration between, the product teams, legal, communications, and so forth to allow the disclosures to be meaningful to the data subject. That means that they can explain to your compliance, your legal teams, what it is the AI is doing, so that you can explain it to the data subjects, but in a way that's meaningful, but not so extensive that you're giving away, your commercial and your IP related secrets.
Yes, and in terms of the marketing of the AI, it's important not to exaggerate what it can do or how fair it is, because this could run afoul various consumer laws and could interfere with your organization's transparency obligations. And finally, check that your Article 22 disclosures are also in sync with your other disclosures to ensure that there are no inconsistencies here.
Yeah, that's all right, I think. And well, anyway, thank you all for joining today's webinar. We're at time. Our contact information is available in the slides. This will be up on our YouTube channel for the Silicon Valley office. And feel free to ping us with any comments or any questions you may have. We're happy to chat.
Yes, we'll be flashing out other AI and data protection considerations in the following webinar. You have the details in the slide. Join our colleagues for the next installment of our AI and data protection mini-series on developing an AI strategy.
Yep, our colleagues Mark Weber and Abby Cannon, they'll be addressing the operationalizing of all this in practice. So, what's good practice, what's good policy, some touching on some new AI rules, all that. Join us on May 13th. We'll send invites accordingly. Thanks. I hope to see you soon. Have a
Thank
good
you.
day.